the year 2022 for Russian pharmaceutical and medical device industries. I am Vsevolod Tyupa, the head of life science and healthcare practice group at Seamless Legal law firm. Seamless Legal is a successor of CMS Russia. CMS is an international law firm who has worked in Russia for 30 years until the events of the previous year. I am here with Ivan Zaraisky, associate of the life science practice group, and our topic is legislative developments and outcomes which has impact on the Russian pharmaceutical and medical device market in 2022. It could be asked, isn't it too late to speak about the results of 2022, given that it's already the 1st of February outside the window? But in our view, indeed, the topic is still current because obviously the situation of the Russian market in general, the situation on the Russian, specifically pharmaceutical and medical device markets in 2023, definitely will be the continuation of 2022. All the trends which were implied by the events of 2022, specifically, of course, February events and military action in Ukraine, will definitely have significant impact to companies in the current year. So in this sense, 2023 will be a continuation of 2022. Let us make a short comeback at the beginning of 2022. At the very beginning of the year, the expectations from the year were rather optimistic. The final victory over the COVID-19 pandemic was expected, even though it's still a current threat to the public health, that was confirmed by the World Health Organization. Nevertheless, at the beginning of the 2022, we were expecting to the opening state borders, return to the pre-crisis level of economic growth, and general recession of the economy, accelerated developments of the healthcare industry. But the reality was actually quite different. There was a start of military action in Ukraine, and that implies significant changes in the Russian economy. A lot of foreign companies have left the Russian market or significantly reduced their presence. There was a mass relocation of employees, and now a lot of Russian citizens are working for their employers outside Russia. The world around Russia was divided into friendly and unfriendly jurisdictions. Unfriendly are those who have introduced sanction packages against Russia, and it includes European Union, United States, Canada, Australia, South Korea, Singapore, and few other countries. So, and there are a lot of packages of sanctions against Russia. There are almost 10 ones up to date. And even though neither sanction package concerns pharmaceutical and medical devices directly, because both medicines and medical devices are traditionally considered as humanitarian products which are outside of any sanctions regimes, there was the case for all the sanctions regimes introduced towards Venezuela, Iran, North Korea, and Russia is not an exclusion. But nevertheless, a lot of pharmaceutical and medical device companies here in Russia either decided to leave the Russian market at all, or at least to significantly reduce its presence. It concerns suspension of clinical trials, significant decrease of investments into manufacturing projects, marketing activities, and even suspension of supplies of certain products. For example, a lot of pharmaceutical companies has decided to continue supplies of IX products, which are considered extremely important, life-saving, but decided to suspend or even terminate supplies of OTC products, which has a lot of or enough domestic analogs. And what are the main obstacles, the main legal issues that such companies decided to leave Russia are facing? First of all, these are regulatory matters concerning termination and suspension of supplies. Under Russian law, if a pharmaceutical or medical device companies which has decided to suspend or terminate supplies of pharmaceutical or medical devices must notify the Russian authorities in advance. In case of medicines, the two authorities, the Federal Service on Surveillance in Healthcare and the Ministry of Industry and Trade, must be notified 1 year in advance. For medical devices, the notification period is equal to 6 months. The companies failing to notify the authority will be under responsibility, which is probably not very high, but not very low. These are around 70,000 rubles for companies for each product, and of up to 15,000 rubles for the responsible officer, CEO, and or other responsible managers. The situation becomes more complicated if such a company holds a dominant position on the market. Then it could be a liability for the abuse of dominance position, which could result in the so-called turnover penalty, which is obviously much higher than the 70,000 rubles. In the probably quite hypothetical but theoretically possible extremely worst case scenario, leaving Russian market could bear the marks of a crime. There is a special article in the Russian Criminal Code for actions or omissions that created significant hazard to public life or health. From the one side, hiding information about suspension of or termination of supplies of life-saving, extremely important medicines could be a marks of some crime, but such interpretation would be very, very conservative, and as of today, we are not aware of any cases under this article. From our experience, especially during the last year, we faced several questions about the procedure of notification and suspension of supplies, which we transferred into the certain FAQ on the most popular, most often questions. The companies ask, is there any difference between the suspension and termination of the products? Because when this dramatic situation in 2022 was just began, a lot of companies thought, is there reasonably enough to leave the Russian market once at all immediately, or it would be more wise just to suspend supplies for a certain period of time and look whether the situation would improve in several months. From a business standpoint, such a dilemma is quite reasonable and clear. From a legal standpoint, actually, there is no difference. So if a company decides either terminate the supplies forever or for many years, or just to suspend for several months, in any case, it must notify the responsible Russian authorities. Otherwise, there is a risk of penalty. Another question is it required to continue importation or production of the product once the notice has been filed with the authorities? Actually, there is no direct answer to this question in the law or in the opinions of the responsible authorities, but we believe that actually it is not required provided that the company has enough stock here in Russia at its local warehouse to satisfy the market needs for the notification period. Simply speaking, if the company has enough products here in Russia for the next 12 or 6 months, then there are no reasonable reasons to continue importation that the company will not sell after the notification period. Of course, if there is a shortage of the product, and then it need to import so much, so it needed to satisfy the market needs. And some companies were, even after taking a decision to suspend the supplies, was thinking about to go back to the market and resume supplies or production a few months later. And there is a question whether it is possible in general when a notification has been already filed and accepted by the authority. The answer is obviously yes. Even if a company, for certain reasons, decided to stop supplies in 2, 3, 6 months later decided to cancel this decision and go back to the Russian market, there are no legal barriers from doing so. Obviously, it is possible. But of course, if the company after this, after going back to the market, would decide to terminate supplies again, then the repeated notification is required, and the company then again would need to wait 6 or 12 months as required by law. However, all these regulatory matters that a company faces when deciding to terminate supplies is not the only and probably not the most complicated legal issues that it faces, because a lot of companies were considering and are considering more, I would say, more heavy, more difficult decision to leave the company in full, to leave the country and either liquidate or sell its Russian branch, its Russian entity. And in the spring of 2022, then there was a significant risk of total exit of foreign business from Russia. The Russian authorities stipulated additional restrictions intended to make the exit from Russia from a corporate law perspective more difficult, more complicated. And now it is required to obtain a preliminary approval, a preliminary clearance from the governmental committee for any transaction concerning Russian companies. That includes both sale of shares of Russian companies or even full liquidation. In order to simply initiate this procedure, a company needs to obtain a governmental clearance first. Now we are working on several such cases. This I'm on our files, and we can say that it is definitely not impossible. So we cannot say that the Russian authorities do not allow leave Russia and do not issue such clearance. This is not the case. But the procedure in general is quite complicated. It requires accounting report, a lot of documents, a lot of justifications why the company has taken such a decision. So this process actually is not simple and not so fast. That makes the liquidation or exit procedure more long-standing, more complicated than it was before. Another difficulty that the company may face is a problem with distribution of dividends outside of Russia. A lot of companies who were investing into Russia over the last decades and had not any plans to leave Russia before the events of February 2022 didn't distribute their dividends to foreign shareholders. After the events of February 2022, a lot of companies were considering about exit from Russia, but previously they would need to take money accumulated with the Russian companies to shareholders. And there is another obstacle introduced by the Russian government intended to make the exit of money from Russia more slow, more difficult. Now, a company that wants to share its dividends to a foreign participant needs to obtain a preliminary approval of the Russian authority, Ministry of Finance, if it wants to pay dividends at the amount of more than 10 million rubles per month. 10 million rubles at the current exchange rate is around 150,000 US dollars, so not so much. This amount not that big. Again, such amount around 150,000 dollars can be paid per month without any problems, and any amount exceeding that amount must be either kept on the special account as with a Russian bank. This money actually, frankly speaking, they're actually frozen and may be used only for payments of state taxes, duties, and penalties. Or a company needs to obtain a special permission of the Russian Ministry of Finance to pay its dividends to a foreign shareholder. This concerns, it concerns only unfriendly jurisdiction. It is not, it doesn't matter for the friendly jurisdictions. That includes China, India, and some other countries whose pharmaceutical industry is also presented in Russia. We are talking about only unfriendly jurisdiction, European and US companies. Again, we also have and now working on obtaining such permissions for some of our clients, and the situation is the same as with clearance for liquidation. From the one side, it is not impossible. We have had success and helped our clients to receive some clearances that allow Russian companies to pay dividends in the needed amount. But from the other sides, again, as any kind of governmental permission, it is not very simple. It requires filing a lot of documents with the Russian authorities, supported with certain kind of justifications, explanations, etc. So this process is not very simple. However, it's doable, definitely doable. And completing our speech, our part about difficulties of further work of foreign pharmaceutical and medical device companies in Russia, especially those from unfriendly states. Obviously, these difficulties have affected Russian pharmaceutical and medical device market at all. In general, it created several problems. The key of which is product deficiency, shortage of certain product at the Russian market, and some other problems, which will be disclosed by my colleague Ivan Zaraisky. Ivan, the floor is yours.
Yes, thank you, Vsevolod. Hello, everyone. Further, we will discuss some measures for combating the shortage of foreign products in Russia. As you may know, the Russian government is struggling to prevent the lack of foreign products, especially medical ones, and 4 measures for combating such deficiency came in place. So the first 2 are the fast-track registration for analogous of shortage medicines and the possibility to import medicines in foreign packages if such medicines are already registered in Russia. The application of both measures by the company requires the obtaining of special opinion from the governmental commission. In this opinion, the commission decides whether there is a shortage or is the risk of shortage in relation to a particular medicine. If yes, then the company can proceed with the fast registration of analogous medicine or start to import the medicines in a foreign package to Russia. So, and when we speak about the fast registration of medicines, of analogous medicines, it is important to understand which medicine can be considered as analogous, actually. And such medicine shall meet 3 criteria. The first, its INN shall be already registered in Russia. The second, it shall be applied within the same clinical indications as the shortage medicine. And the last one, it shall target the same, it shall have the same biological target as the shortage medicine. Okay, and the next measure allows the company to register the medical device using the fast registration procedure if such device is included in the special list of devices in relation to which the shortage is possible. Such list is administered by the Federal Service for Surveillance in Healthcare and is drawn up by the Special Commission and is available on the website of the mentioned authority. The last measure relates to the drugs included in the essential drugs list. As you may know, if the medicine is included in such list, then its it can be sold in Russia at a price not higher than the registered one. Okay, but if the currency fluctuations cause the circulation of medicine at this price, at the registered price, unprofitable and consequently cause the deficiency of this medicine, then the company can re-register the price using the new exchange rate and consequently increase the registered price. I think we can go to the next slide. Thank you. The parallel import. Just to refresh the memory of what the parallel import is, it is an unauthorized import in a country A of goods which were lawfully put in circulation in a country B. When I say lawfully, I mean that the goods were put in circulation by the trademark holder or at least upon its consent. The partial legalization of the parallel import model is one of the responses of the Russian government to the exit of many brands from Russia. And the logic is that, okay, you can leave Russia, you can exit our country, take your goods back with you, stop the supplies, but we will allow other companies to take your goods, supply them to Russia, sell them, gain some money without any liability to the company that left Russia. Such goods in relation to which the parallel import is allowed are included in the special list administered by the Ministry of Industry and Trade. And this list mentions the product by their type, by their customs code, and sometimes by their brand also. As of today, we are not aware of any cases of application of this list to medicines or medical devices, but the ministry already commented that the list is dynamic, it can be updated from time to time, so we cannot fully exclude that one day, for example, if the shortage occurs, dramatic lack of medicines, for example, occurs, that the medical or medicines will occur on the list one day. Okay, we can move further. The compulsory licensing. Again, the compulsory licensing is a mechanism that allows the Russian government to grant the license to patent without the consent of the patent holder, and reason it by some matters of public health protection. And in turn, the lack of medicines or medical devices can be, at least theoretically, considered as the hazard to people's life and health. And after many brands announced that they exit Russia, some Russian officials commented that Russia is ready to enforce the compulsory licensing mechanism to prevent the shortage of products, and many companies took this risk very seriously and paid great attention to its assessment. And now the question is whether there is a solid ground for such concerns. Okay? From the one hand, usually under the compulsory license, the royalties shall be paid in favor of a patent holder, regardless of the fact that the license was granted without his consent. Okay? He is still entitled for the royalties. But in 2022, the government established that the royalties under the compulsory license cannot be paid in favor of patent holders from so-called unfriendly states. And this is the sign that the government prepares for something and that its interest in this mechanism increases. But on the other hand, looking back in 2022, we see that there was no significant increase in the number of compulsory licenses granted, and this number is more or less the same as in previous years. Therefore, in my opinion, the companies definitely should keep in mind that the risk of compulsory licensing exists, but please do not overestimate it, because there are no solid reasons for it now. Okay, we can move further. Okay, the equipment export restrictions. In the past year, the Russian government imposed various bans and restrictions on export from Russia of various equipment. You can see the very complicated and detailed slide, which provides for the full history of introduction of such bans and restrictions in Russian legislation. I will give you some general comments to understand which regulations are important and how to use them to understand whether the export of your equipment from Russia is possible or not. So the first decree number 302 is no longer in force, so we can forget about it. The decree number 313 is still in force, but I don't think that it can touch any of our attendees because it covers basically the military equipment. But the decrees number 311 and 312 may cause a lot of difficulties for life sciences companies. They so if you want to export some equipment from Russia, you need to check whether your equipment occurs in this list, and if yes, most probably its exportation outside Russia will be prohibited unless it is the exportation to one of the countries of the Eurasian Union or to Abkhazia or South Ossetia. The exportation to these countries is most probably will be allowed upon the special permission from one of the several authorities, depending on the particular type of the equipment to be exported. Okay, so again, decrees number 311 and 312. Please check before the exportation whether the equipment included in these acts. If yes, please pay great attention and please approach to the exportation very carefully. Thank you. I think this is the end of our presentation, and we can go to the Q&A session in case of any questions.
Thank you, Ivan. Thank you, everyone. Dear colleagues, unless you have any questions that you may send to our chat and we will see it, if any. We may complete our presentation, so let us wait about a half of minute. Okay, thank you so much, dear colleagues. Let us also take this opportunity to wish you all the best for 2023 and have a very productive and happy upcoming year. So hope to see you soon on our next webinars. And also let me wish you success with Russian market, even though it's quite complicated and problematic right now, but I believe it's still attractive. So if you're interested in this our presentation, probably let me wish you to be successful in Russia, notwithstanding of any reasons and factors. Thank you so much for joining us and have a nice day or evening for our Asian colleagues. Bye-bye.